The defense may then argue, the state may then reply. State, you need, give me a second. Is it on? Good.
Thank you for your time and attention, ladies and gentlemen. It's been a long 7 days, I think, that we've been able to all be in this courtroom together. So I thank you for your time and attention in this case. On February 29th of 2020, the defendant, Mr. Cummings, shot and killed Guillermo Arriola at his ranch in Sandoval County. As I said at the beginning in opening statements, we know who did this, and we know how he did it. And so you are the finders of fact. It's your job to determine whether or not this crime was committed with sufficient provocation, making it a voluntary manslaughter, or without sufficient provocation, making it a second-degree murder. Or did he commit this homicide in self-defense? This is your job to determine this. The state has presented all of its evidence, and the defendant has presented his evidence. We know that Mr. Cummings shot Mr. Arriola with this AR-15-like rifle with a 30-round magazine by shooting him twice, once in the head and once in the chest. What weapon was used is not an issue, ladies and gentlemen. What magazine was used is not an issue, ladies and gentlemen. We know this. This is fact that we know. Why this is done, this is what you're asked to determine. And the state has presented evidence to you that Mr. Arriola was not armed. The force that was used was not reasonable. As I said in the beginning of this case is about reasonableness. And you, ladies and gentlemen, determine what is reasonable here. As I said, the judges gave you instructions on what the law is. Second-degree murder is not an act as a result of sufficient provocation. Voluntary manslaughter is when someone does act as a result of sufficient provocation. So the only difference is that number 3 for you to decide. So what is sufficient provocation? You're going to have the instructions that the judge read to you. You'll have those to look at, to read, to think about. Would an ordinary person of an average disposition have done the same as Mr. Cummings did? It's not sufficient if someone would have cooled off before acting. Would an average person have walked out of the trailer, cooled off? If Mr. Arriola was acting crazy and aggressive, was that sufficient provocation? Would Mr. Arriola have walked off? As I said, this is a case about reasonableness, and you determine what was reasonable on that day. So let's talk about the evidence in this case. Mr. Cummings was going to purchase this ranch out in Sandoval County for Mr. Arriola. Ms. Landers drew up that real estate contract. She's known Mr. Arriola for about 20 years. He was going to buy it for $149,000, and Mr. Arriola let him park his fifth wheel trailer out there for $300 a month. Ms. Landers told you she thought that Mr. Cummings was taking advantage of him, that this wasn't a fair deal. She said that Mr. Arriola liked Mr. Cummings, and they got along well when she saw them together. She thought that Mr. Cummings also liked Mr. Arriola as well. They were friends. Mr. Arriola had even given Mr. Cummings a horse. She said that she thought Mr. Cummings was kind of strange and something was off about him. They did not yet have an executed contract to purchase that land. Mr. Cummings told you when he took the witness stand that he also thought he got along good with Mr. Arriola. They had a lot in common. They hung out, they drank whiskey, they went horseback riding together. They got along just fine. Mr. Cummings testified that Mr. Arriola told him about an incident with a hammer. He said that Mr. Arriola had told him that he had scared a guy by hitting a car with a hammer. And he thought, hearing that story made him think, well, I better be careful. And this is a man who took the stand and told you about his vertical gains, and he made a living as a world-class skier. He told you he took multiple helicopter runs up an amazing big mountain, and that this dangerous career of his required technique and athleticism. But he thought I should be careful because an old man told me a story that happened years ago about a hammer. Is that reasonable? Mr. Cummings testified that he arrived at Mr. Arriola's trailer at about 10 or 11 p.m. the night before. He said that he was watching a movie and he dozed off. He thought that he smelled propane, and so he went to his fifth wheel trailer. Mr. Arriola arrives at the ranch the next day, February 29th, 2020, leap day. Mr. Cummings said that he believes Mr. Arriola arrived at 1:32 p.m., broad daylight. Remember, this area is so remote. Mr. Cummings could see him coming from a distance. This area is so remote, he would have heard a large truck approaching this ranch in the middle of nowhere. He had time to prepare his attack. Mr. Cummings testified about what happened that day. He told you, ladies and gentlemen, that he was in the kitchen and Mr. Arriola was unloading groceries with a scowl on his face. They talked for 8 to 10 minutes, is what he told you. And that because he called Mr. Arriola a scammer, that made Mr. Arriola so mad that he attacked him out of nowhere, just for being called a scammer. Mind you, Ms. Landers believed that the contract was in Mr. Cummings' benefit. He was going to live there for $300 a month, had full access to that land, was given a horse for $300 a month. Mr. Cummings told you that he was slammed into the counter and fell to the ground. And he grabbed his rifle from the wall and crab walked down the hallway while Mr. Arriola is swinging at him, not hitting him, but swinging at him. At the beginning of this trial, ladies and gentlemen, I told you that Mr. Arriola can't tell us what happened that day. The evidence will show what happened that day. And is it reasonable to believe that Mr. Arriola, because he was called a scammer, would attack Mr. Cummings, this professional athlete? This is a case of reasonableness. Or is it more reasonable to believe that Mr. Cummings made up this story to cover what he did? You're the judges of the credibility of the witnesses. You saw every witness take that stand. You saw all of the evidence admitted. You determine who to believe. You determine what's true on that witness stand. You heard a story of Mr. Cummings and how what he told you contradicted every witness that took that stand. It contradicted what Mr. McCullough said happened, what Ms. Landers said would happen, what the responding deputies said would happen, what's recorded on the ballot tape of the responding deputies, what the 911 calls say. He disagrees. Even his own expert. His testimony even contradicted his own expert. We know Mr. Cummings shot and killed Mr. Arriola. He doesn't immediately run out and go get help. He doesn't think, hey, I need to call an ambulance. No. He said, I got to go wash my face and hands. And I got to go back and I got to get soap. And I got to go back out and wash my hands. He changes his clothing. He walks around the ranch. He even said that he's medically trained. And he walked over, peeked in the window, and saw that Mr. Arriola wasn't breathing. His chest wasn't moving is what he told you guys. But he was lying face down. Mr. Cummings told you, ladies and gentlemen, that at about 3:30 p.m., is the time he believes he was washing his hands off, his face, changing clothes. So if Mr. Arriola arrived at the ranch at 1:30, what did he do between 1:30 and 3:30? That's 2 hours of unaccounted time for. Mr. McCullough called 911 at 5:30. What happened between 3:30 and 5:30? That's 4 hours of unaccounted time for. Let's talk about Mr. McCullough. Mr. McCullough testified that he was out riding his dirt bike out at Cabazon Peak. He said that he was driving at a Y intersection. He went to the right until the road ended, and he saw a male walking around outside by some structures. He said he couldn't quite look at the male, because he was trying to keep his bike on the road, and so he turned around and went back to that Cabazon Peak point of interest sign that he wanted to read. He said that Mr. Cummings came up to him while he was at this sign, and he starts talking to him about motorcycles. I like the motorcycle, telling him how he likes motorcycles. And they have this friendly conversation with a stranger about outdoor sports. He doesn't say, I need help or anything of that nature. Can you call 911? No. He's like, hey, let's talk about motorcycles. That goes to the reasonableness of his actions on that day. Mr. Cummings then drives off, not to get help, not to get cell phone service, which is 4 miles from the ranch. And then he decides, you know what, Mr. McCullough is going to be a good witness for him. So he drives back, talks to Mr. McCullough again, some more. They're chit-chatting. And then when Mr. McCullough goes to leave is when he waves him back over and says, I'm in a little bit of trouble and I need help. When Mr. Cummings took the stand, he denied that he ever left and came back. His story contradicts Mr. McCullough. So you judge the credibility of the witnesses. Mr. McCullough testified that the defendant told him he needs help. Not Mr. Arriola needs help. Mr. Cummings needs help. He tells Mr. McCullough that he was sprayed with a poison. He never said mace. He never said I was in a fight for my life with his gun. He said I was sprayed with a poison. And the poison burned his skin and his face and made it difficult for him to breathe. Mr. McCullough sees no injuries. He said he didn't see anything on Mr. Cummings that night. He never told any witness that he was in a fight, that he was in a battle for his life with that gun. Not law enforcement, not Mr. McCullough, nobody. He said that he was sprayed with poison. That is the one consistent thing he tells all of the witnesses. And that is the one thing he's holding on to. He wants to make sure that everybody is a witness to this can. Everyone needs to see that Mr. Arriola had this in his hand. And I urge you, ladies and gentlemen, to feel this. Hold it. So Mr. McCullough pulls out his cell phone, calls 911, and you have the 911 calls and evidence, and I urge you to listen to them. You can hear in the fourth audio, Mr. Cummings is talking in the background. You can hear in the audio on the first and second calls, he's talking to a friend. He's not calling the 911 operator. You can hear him in the fourth audio call calling the 911 operator. So in calls 1 and 2, he's chatting with a friend. You can hear him in that call telling this friend that he doesn't feel too good and his whole left side. Something about his whole left side. But he testified that his right side was sprayed, to you, ladies and gentlemen. Mr. Cummings didn't call law enforcement until 13 minutes after Mr. McCullough did. You heard Mr. Cummings testify that he was 10 feet away from the truck. Mr. McCullough was 10 feet away from the truck. He wasn't asking him any questions about where the gun is and if anyone needs help. But you can hear the calls, and you can hear those questions being asked. But that's what Mr. Cummings told you, ladies and gentlemen. He said that he called his dad. And Mr. McCullough described the demeanor of Mr. Cummings on that night as calm, not at all frantic or upset. Is that reasonable? He just shot and killed a man and is hanging out with a stranger talking about motorcycles. Is that reasonable? Mr. Cummings tells Mr. McCullough that he washed his hands, changed his clothes, washed his face, and that the gun is in the back of his truck. And he told you a different story. He said that he immediately put that gun against the porch. So again, his testimony contradicts what Mr. McCullough said. Mr. Cummings asked Mr. McCullough to be his witness that the guy attacked him. And Mr. McCullough told you, ladies and gentlemen, how could I do that? I wasn't a witness to anything like that. I wasn't there. Mr. McCullough follows Mr. Cummings back to the ranch to see if he could render any aid. But Mr. Arriola was past the point of aid. He said he was bluish or grayish. But he wanted to make sure that Mr. McCullough saw what was in Mr. Arriola's right hand. You heard Mr. McCullough say that Mr. Cummings really wanted him to see that black canister because he wanted to make sure that he had a witness that Mr. Arriola had attacked him with the black canister. Mr. Cummings was obsessed with showing everyone that Mr. Arriola had a can of poison. He needed a witness to this poison. And again, he never told anybody there was a struggle. He needed a witness to this. This was his focus. Mr. McCullough was the first person in that trailer after the homicide. He smelled nothing. No poison, no neurological agent, no mace. Mr. Cummings made this whole thing up to justify what he did. And you can see in that photo that can is facing Mr. Arriola. Mr. McCullough goes to Cabazon Peak to wait to law enforcement, and he said that he took out his ID because he knew that law enforcement would want it. So he was there waiting for law enforcement to lead him back to the ranch. Mr. McCullough's call was at 5:31. Law enforcement is dispatched at 5:40, and Sergeant Crispin testified that they met with the calling party, Mr. McCullough, at 6:26 p.m. Again, more time. Mr. McCullough isn't there, and Mr. Cummings isn't there. He's back at the ranch. There's more time there. Law enforcement goes to the ranch and they encounter Mr. Cummings at his truck at the exit. And he tells law enforcement, as soon as they come upon him, self-defense, self-defense. He says that he was harmed by a neurological agent. And you can listen to Deputy Walker's belt tape. You can hear him say he was harmed by a neurological agent. He told Deputy Walker that it must have been chlorophyll. And Deputy Walker testified that he didn't see any injuries on Mr. Cummings. He had no symptoms that he would expect to see of somebody who has been sprayed by a neurological agent or mace. No red eyes, no red skin, no rash, nothing of that nature. Listen to this belt tape. There's no panic in Mr. Cummings' voice. He's not frantic in any way. He doesn't ever say he's in a fight for his life. They do a protective sweep of the residence, and he said Sergeant Crispin hung out at the car with Mr. Cummings. And Sergeant Crispin testified that he had been asking Mr. Cummings for his name and his date of birth for about 3 hours. And all he would say is Dean, Dean. And you heard they don't have radio dispatch out there. They're not getting the calls from dispatch that Mr. Cummings had called in. They have to drive 4 miles down the road to get radio service, to get cell service. They're not leaving the ranch. They're there to secure the scene. Even on Deputy Walker's belt tape, towards the end, you can hear the defendant tell the deputies, did you see the device in his hand? Did you see the device in his hand? He wants to make sure everyone's a witness to the device. You heard testimony that Deputy Gutierrez and Sergeant Griffin arrive on scene as well at about 7:30 p.m. Mr. Cummings is evaluated by EMS and released. He's not transported for any injuries from the poison or the chlorophyll or the neurological agent. They take photos of him. There's no injuries on his person that are documented in these photos. There's no rash, no redness, no bruising, no scratches from a fight for his life. Nothing indicative of a fight is on his body. His knuckles don't have injuries from being in a fight, a physical altercation. He didn't tell anybody he had any burns on his hands. Even the expert witness couldn't say what was on his hands other than there's black smudge on his hands. Nobody knows what that is. He could have touched anything in the hours he had from the time he killed Mr. Arriola to the time these photos are taken. While he's being photographed by law enforcement, he tells them that, yeah, he washed off with a hose outside after being sprayed with the neurological agent. He says his clothes are in the back of the truck. Sergeant Griffin testified that they were wet when they collected the clothes, and you can see the clothes, they're in evidence. The t-shirt clearly looks like it was folded up when it was wet. It's got the wrinkled marks on it. Sergeant Griffin said he smelled nothing on the clothes he collected. New Mexico State Police arrived to process the scene. You heard from Agent Carlos Herrera. Agent Bogue did the diagrams of the scene, and Agent Edgar Lemus helped collected evidence and took photographs. Agent Herrera stated that he collected 11 spent casings from that bedroom. Now think about that. 11 spent casings. That means that Mr. Cummings shot that rifle approximately 11 times in that little bedroom. Now we heard testimony about 2 to the body and 1 grazed the clothes and 3 through the door. That's not all 11. Mr. Arriola didn't have a chance. He was unarmed, and you have an AR-like rifle and 11 spent casings. Not 1 shot, 2 shots, 3 shots, 4 shots, 5, 6, 7, 8, 9, 10, 11. You heard testimony that the majority of the casings were on the side of the room with the wall. So if the shooter was looking towards the door, these casings are expelling from the firearm to the right. And the majority of the casings are along that wall there. So the shooter must have been facing the door if the casings are popping out that way. 1 casing was on the other side of the room. There's even a casing on that plastic tote. So we know the plastic tote was there. So number 3 on the evidence tag, that's the casing on the other side of the room. There was only 1. If the rifle expels these spent casings from the right side of the gun from the shooter, then we know that the majority of the shots were shot facing towards the door. If the gun was upside down, like the expert said it potentially could have been, then the casings would have expelled the opposite direction. And we have 1 spent casing on that side. And you heard they can move around, but the majority are on the right, on the other side of Mr. Arriola's body. You saw Mr. Cummings' reenactment of what he believed happened that day. He said that he shot 2 times into the ground. And we heard testimony about the muzzle patterns. But when Mr. Cummings came and did his reenactment, ladies and gentlemen, in this small room, when he did it with that little blue gun, he pointed it directly at the ground. He never, in his reenactment, ever said the gun was upside down. That's different than what his expert said. More casings. Let's talk about the rest of the residence. This is the door outside, to go outside, right directly across from the bathroom. You heard Mr. Cummings tell you, ladies and gentlemen, that yes, he went into the bathroom, and that he was able to, at that point, when he was in the bathroom, he was able to pull the lever back. This is not an easy task. And make the rifle ready, chamber it around. This takes affirmative effort to do that. And he's going to tell you, ladies and gentlemen, that after he chambered around, Mr. Arriola continued to still attack him. Is that reasonable? If somebody pulls a rifle, chambers around, are you going to still continue to attack that person, or are you going to go out that door? Are you going to directly turn around right outside that door and go out the porch? What's reasonable, ladies and gentlemen? He could have went to the kitchen, gone out the other door, out the other side. What about the rest of the residents? There's no signs of a struggle. The only one who says there's a struggle is Mr. Cummings. None of the evidence shows that. There's no signs of fight. There's the other door. The kitchen has no signs of a fight. Nothing is broken. No broken dishes. If you're a parent, you know not to leave a pot with the handle out. That wasn't disturbed. Nothing on the counter. We see the sunglasses. Supposedly they're Mr. Arriola's sunglasses on the ground. That's the only thing out of place in this room. So what's reasonable? If there was a fight and Mr. Cummings said he was slammed into the counter, nothing is disturbed on the counter. He was slammed into this counter. Those cans are still on the edge. Nothing is disturbed on that counter where he was allegedly slammed into. In the bedroom, there was this big fight in the bedroom. You had clothing on the wall. This is a manufactured home, a mobile home. The walls aren't the strongest. If you've ever been in a manufactured home, you know that you can push them. They're flexible. There's a hat hanging on the coat rack, and that mirror is perched against the wall there. Mr. Cummings testified that he believed that the heater was on the wall. There's no scratches on that wall. If they were in this big battle for their life and they knocked over that heater, wouldn't the wall be scratched from the heater being knocked over? There's no physical evidence of a fight. On the other side of the room, clothes are hanging still. Not a little bit of clothes. It looks like a lot of clothes on that hanger. The lid of that plastic bin is precariously open. That wasn't disturbed either. Now, let's talk about this photo. You heard Mr. Brudenell, the expert, testify that the shooter must have been either between the two beds, the bunk bed and the other bed, or over by that wall. So he said that the shooter must have been here, or here. It's not a lot of space. If this is our room here, and we have two beds, a bunk bed here and a bed here, there's not a lot of space. There was a struggle. That stuff would have been disturbed. Something would have been knocked over. The expert testified that Mr. Arriola must have been parallel to the floor. He could have been on all fours. That's a vulnerable position. He's not fighting anybody on all fours. But the wounds show it. He was shot right to left. So that's why the shooter would have been here on this side, right? Right to left. And from an upward position downward. The trajectory was downward. So that means the shooter is raised above the person who was shot. So Mr. Arriola could have been on all fours. You heard that. That's not someone who's fighting. That's not self-defense. Someone on all fours. Or he could have been bent over. Again, that's a vulnerable position. You're not fighting someone if you're bent over and they have a rifle pointing at you. Janelle says that, and OMI says that. They both said the same thing. The decedent could have been on all fours or was bent over. That's what the evidence shows. The defendant, in his reenactment to you, ladies and gentlemen, he said that Mr. Arriola was coming at him, and he was crab walking, holding a gun, fighting him off. How can you crab walk? He was fighting him off, and he's the one on the ground. And in his reenactment, he said that Mr. Arriola was standing above him. That's not what the evidence shows. The evidence shows a downward trajectory, not an upward. The shooter was above the person being shot. That's a vulnerable position. Let's talk about the mace. No witness ever said the mace was sprayed. Mr. Cummings said maybe, he was kind of unsure, and on redirect, then he said it was sprayed. He's the only one who said that. This is a self-serving statement. There's no physical evidence to support this. Mr. Cummings didn't even call it mace. He called it a neurological agent, or chlorophyll, or poison. Law enforcement testified that they've been sprayed. They do this as part of their job and training, that it could last anywhere from 45 minutes to 2 days. And you heard a lot of this in voir dire. It gets on your clothing. They also said that an excess will drip out when it's sprayed. There's no excess. None on Mr. Arriola's hand and none on the floor. It has a distinct smell. And water could reactivate it. Mr. Cummings said he washed off with the hose spigot. He was just spreading it. When you put water, it just spreads it to other parts. He said he used soap and washed more. You heard testimony that Mr. Arriola was known to carry mace with a dye. It's probably not the same can of mace from that 2017 incident. He probably got another can. There's no red dye in that room. And you can look at the can of mace. It appears that there's a red dye, and I encourage you to look at it. There's dirt in there. This hasn't been used. Mr. Cummings set up this scene so that he can claim self-defense, to justify his unreasonable actions. Mr. Arriola was not armed. This can is facing the wrong way, and in order to utilize this can, you have to lift up the top and then spray. There's no way he could do that from that position. It's in his hand. No one falls over with something in your hand. If you're going to fall with your hands out to brace your fall. You're not going to fall with something in your hand. If someone is shot, they likely grab whatever area they're shot at and they go forward. If Mr. Arriola was shot to the head first, you heard OMI that would have been an instant kill. He wouldn't have survived much longer after that. If he was shot to the head first, he would have been fallen face first and not likely to hold anything in his hand. Let's talk about Dr. Gerald, the OMI doctor. She said that Mr. Arriola was 5'9", 199 pounds. And he's supposedly in this fight for his life with a professional athlete. Mr. Arriola had 2 gunshot wounds. The first one she talked about entered at the right temple, went through the oral cavity of the neck, broke 3 cervical vertebrae, and left fragments in the chest. And the second shot, she said, was to the supraclavicle region. I'm not good with the science terms. And it exited out the other side of his chest. The first one was, she said, an intermediate range. And the second one was a distant range. Dr. Gerald said that those injuries were from right to left in a downward trajectory. The shooter was above Mr. Arriola. She said Mr. Arriola could have been kneeling. Other than the injury to Mr. Arriola, he had an injury to his nose. He had some bruising she could not age, I believe she said on the back of one of the thighs. And you have the body diagram. But other than that, he had no scrapes. He had no injuries from this fight. His knuckles aren't damaged from a fight. There's no scratches. There's no abrasions. Nothing of that nature. He has no burns on his hands from supposedly grabbing a hot barrel. The expert said that the rifle barrel, when it's shot, it's a ball of gas essentially coming out, and it would have been hot. You also heard from Dr. Jarrell about the toxicology, that Mr. Arriola had cocaine, alcohol, and marijuana. There's no information. She couldn't tell you how that would affect Mr. Arriola particularly. She just said it could cause aggressiveness and it could cause risk-taking, but she couldn't say how it affects one particular person. And she admitted she has no knowledge of how the testing process goes, and she was just reading what potentially could happen to someone from a piece of paper. They collected a straw, pen, and papers. Again, this stuff wasn't tested. There's no evidence. You heard that it may be consistent with drug use. Let's talk about the DNA. Jennifer Otto of the New Mexico Department of Public Safety Lab, she did serology testing. That's testing of the bodily fluids. And she said that the clothing Mr. Cummings wore was tested. His clothing that he said he wore at the time of this, that was wet when it was collected, had no blood on it. So that means that he was standing far enough away from Mr. Arriola when he shot him that there wasn't even any blood on his clothing. Let's talk about the DNA testing she did. She said that she tested the rifle, and Mr. Cummings' DNA could not be eliminated. But there was a mixture there, so he could potentially be there. But Mr. Arriola was eliminated as a contributor to the DNA. And you heard about the different areas of the gun that were tested, and you saw the reenactment from Mr. Cummings when he said, yes, Mr. Arriola was grabbing everywhere all over the gun. He tested multiple areas of this gun, and Mr. Arriola's DNA was not on this gun. He didn't touch this gun. The mace can. There's 2 DNA contributors on the mace can. Mr. Arriola was the major DNA contributor, and Mr. Cummings was eliminated. If Mr. Cummings had time to set up the scene, he could have wiped the can like you see in movies and then put it into the can, just the way he wanted everyone to witness the can in the hand. They took swabs from Mr. Cummings' face and hands. There were 2 contributors. Mr. Cummings' DNA was there. Obviously, it's his body, his swabs. That's not a surprise. But Mr. Arriola was eliminated. This was a physical fight. Mr. Arriola's DNA would have been on his face or his hands if they're fighting for the gun. They also tested the fingernail clippings for Mr. Arriola, and there was no DNA foreign to Mr. Arriola. So that means Mr. Cummings' DNA wasn't underneath his fingernails. There's not a fight. That's not a surprise. Let's talk about Lieutenant Tomlinson. He testified about the limitations of their radios and the CAD system and the body-worn cameras and belt tapes, and that Sandoval County is the largest geographical county, and they typically on a normal shift have 4 to 5 deputies for this huge county to cover on every shift. You heard him say that he testified at grand jury on March 19th, 2020, and he was asked on cross-examination, how can you say that drugs and alcohol were not an issue when he was asked this on cross-examination? And you heard him. This grand jury was on March 19th. He didn't have toxicology. He didn't know. He can't say that it was. He didn't have that information. He didn't have Agent Herrera's report. Agent Herrera's report didn't come out until April 7th. And Lieutenant Tomlinson also testified that he believed Mr. Arriola entered the room, bent and turned the other direction, entered the room, bent and turned the other direction and went to leave, and that's why the body landed in the position that it landed. because of momentum. He also testified that Mr. Cummings also had marijuana. And he was in the presence of Mr. Cummings for 6 hours, and he also saw no injuries. You also have to determine that this wasn't self-defense. And the evidence shows that this was not self-defense. The only one who says it's self-defense is Mr. Cummings, who wants everyone to witness the can. You saw some photos about splotches on a gun. Agent Herrera said it could be stippling gun residue. It could be cleaning oil, Agent Herrera said. The expert said it could be cleaning oil. Sergeant Griffin said it could be cleaning oil. If the defendant had just taped on the scope with electrical tape, he could have cleaned the gun. There's no evidence whatsoever what those splotches are. Even the mace. There's no evidence it was ever sprayed. The self-defense instruction says that you need to determine whether or not there is an appearance of immediate danger of death. Does this give the appearance of an immediate danger of death or great bodily harm? Would a reasonable person believe you're in immediate danger of death? The muzzle patterns, you heard the expert testify, they can't be aged. There's no way for him to tell if they were hours apart, days apart. If Mr. Cummings had time to put this in Mr. Arriola's hand, he had time to put those marks in the ground. There was hours unaccounted for. He didn't go get help. He didn't drive 4 miles down the road to get cell phone service. He was there for hours. Mr. Cummings, when he testified, he showed you his reenactment. This is how small the room is. Nothing's disturbed in that small room. He said he was crab walking. He said that he was pulling Mr. Arriola by his jacket. Mr. Arriola doesn't have a jacket. There's no jacket collected. No jacket was ever mentioned until Mr. Cummings said that. Mr. Cummings said that Mr. Arriola pulled the barrel of the gun against his trigger finger. How reasonable is that? If Mr. Arriola is pulling the gun by the barrel against his trigger finger, he would have burns on his hands. His hands would have been shot. How reasonable is Mr. Cummings' story that someone's going to pull the gun against your trigger finger? This story is not reasonable. His story. It's a self-serving statement made up to justify what he did, and you determine the credibility of the witnesses. His story contradicts everything that every other witness said, every piece of audio we have. This is not self-defense. It requires that he was in fact put in fear by the apparent danger of immediate death or great bodily harm. And mace is not that. There's no immediate death. There's no great bodily harm. His actions weren't reasonable. And we would ask that you find him guilty of the second-degree murder because he was not provoked. Mr. Arriola was unarmed when he shot and killed him. Or the lesser included offense if you think he was sufficiently provoked of voluntary manslaughter. Thank you.
Defense.